Good evening, everyone. Let's run a quick audio-visual check before we begin. Am I audible? Am I visible to everybody? Is the screen visible? Yes. Am I audible? Am I visible to everyone? Quick audio-visual check, then we begin. Yes, I think there was some technical error. Okay, good evening, everybody. Let's start off once again. Am I audible? Am I visible to everyone? Yes, today's our YouTube session on the 22nd Law Commission's recommendation on sedition, something which has been in news for the past couple of years for various reasons. And this year again, in the month of May, there was a recommendation which was made by the Law Commission. Different views on that recommendation. Some people are in favor, generally a lot of people are not too happy with that. So we are going to be discussing what exactly was the recommendations, right? So today's session, we are not going to be being swayed by what is coming in the newspapers and the magazines as to how it should be interpreted or how it should be seen or how, whether it's good or bad. We are not going to be taking sides. Rather, the focus today is going to be on the fact that what exactly are the recommendations, right? So that is the most crucial thing because, I believe all of you here in the audience are wanting to be lawyers, right? So for lawyers, it is very, very essential that you should base your arguments on what exactly are the facts, right? So today what we are going to do is आज हम focus करेंगे सिर्फ अपने facts के ऊपर कि भाई law commission की recommendation आखिर थी क्या on sedition, right? Okay, so first of all, like I was saying, am I visible? Am I audible to everybody? Type a quick yes in the chat box in your YouTube. I would be looking at the comments, other questions, whatever you are going to be posting online. It's a live session. So whatever you ask, I would be taking up then and there, right? So that is the reason I'm asking. Quickly put a yes in the chat box. Okay, I'm giving you guys a minute to do that. Let me see. Yes. Aditi says yes. Okay, Ayush says yes. Okay, that means my message is getting through, right? So that is something which is essential. I know, in these YouTube sessions, there tends to be a slight lag between when you answer and when I really address that issue, but don't worry, that much we can take care of, right? Okay, so to begin with, in today's session, what we will first begin with is what exactly is the Law Commission. You know, when you hear or when you read about, you might come across passages in your legal section in which they might mention the word Law Commission again and again. But let's have a clarity as to what exactly do you mean by a Law Commission, right? So when you look at the word Law Commission is basically, first of all, it is a non-statutory body, right? That means it is not a body which is being made under a particular law. Now, a statute is generally what we refer to a law. So when you're looking at the Law Commission, there is no statute under which the Law Commission has been established. Rather, Law Commission is something which is a legacy that we have inherited from the Britishers. So when you look at the first Law Commission of India. The first Law Commission of India was one which was established not after independence, but it was in the pre-independence era, right? So it was the Britishers who had first established the Law Commission, the concept of Law Commission. That was the first Law Commission which was established during colonial rule, right? So Lord Macaulay was the one under whose presidency, who presided over the first Law Commission of India. So 1883 Charter Act was there, under which the Lord Macaulay had headed the first Law Commission. Thereafter, during the British rule, there were about 3 more Law Commissions. So in total, there were about 4 Law Commissions which were there. And, you know, when you look at these Law Commissions, why is it that we're looking at the history? Now, some of you might feel that, all this history is not something of value in legal reasoning. Now, there I beg to differ, because sometimes, when you get your passages, these passages are based on understanding of legal concepts. And a lot of times, which you will see even when we go through the Law Commission's report, a lot of stress is laid on history. How did this law actually come about? What is the origin of law? That will tell you whether the law is still valid in the present times or not, right? So that's the reason why when you look at these law commissions which were there, even though they were prior independence, the laws which they helped in enacting are still being used in India. Of course, there have been amendments time and again after independence, so that, they are in accordance with the constitution, in accordance with what is needed in our country today, right? But things like the CPC, the Civil Procedure Code, the Indian Contract Act, the Indian Evidence Act, all these laws were made prior to independence, right? And these law commissions were the ones who were really helping. Now, this is something which happened in the pre-independence era. These were there to help the Britishers make laws, whatever law reforms they needed. These law commissions were there to advise them, aid them in making those laws. Now, after independence also, it was felt that, we do need a body which would help the government, which would help the legislature in making these laws. That is when, after the independence, the first Law Commission of India came into existence in 1950. So 1955 was the first Law Commission of India, and the then Attorney General, Mr. M.C. Setalvad, he was the chairperson of that particular commission, right? Now, since then, since 1955 till date, 2023, we've had about 22 law commissions in the country. So the present Law Commission which we have is the 22nd Law Commission of the country, right? Now, generally, these law commissions have a term of 3 years. So there's a 3 years term for the law commissions usually, though I'm sure if you guys are following up on your, your GK, your current legal news and everything, you would be aware that there is an extension which has been granted to the present law commission. Anybody has any clue on this? Has there an extension been granted to the 22nd Law Commission? Yes? Do I have any of you following up? Can you answer me whether an extension has been granted? Whether this 3 years is what the present Law Commission is also still under those 3 years which were initially there? Right? Yes, I think yes. So here, when you look at it, the present 22nd Law Commission has been granted an extension, right? They were supposed to, they were established in February 2020, and they were supposed to come to an end in 2023, Feb. But the extension has been granted there, and they are going to be there till about 31st August 2024, right? So there's an extension which is being granted to the 22nd Law Commission, right? Okay, so that was a little bit of history. What is the purpose behind the Law Commission's post-independence? They say that it's for reforming the laws for maximizing justice in society and promoting good governance, right? So when you look at what is the purpose, these are the two basic purposes for which the Law Commissions are making their recommendations, or rather, what are they trying to achieve? Now, whenever a law commission is there and they're supposed to give you some sort of reform or some sort of an advice as to what needs to be done, then there is always a term of reference which is given to the law commission, right? The terms of reference means that what is it that the law commission can recommend? What are the recommendations that the Law Commission needs to make? So what it would include: repealing, reviewing obsolete laws, a law which is not relevant anymore, ensuring that laws which affect the poor and outcast and everybody is basically taken care of. Then also another important thing is particular to examine the existing laws in the light of directive principles of state policy. Now, DPSP, Law Commission always have a very important role as to, that whatever is given in the DPSP, now that is supposed to be the ideal utopic country that we want to achieve. So when we are talking about giving justice, providing justice, we're also talking about trying to ensure that DPSP somewhere or the other, how far can we try to bring it into force? Of course, because the PSPs are by themselves not enforceable. So the Law Commission also has this role. In fact, that is why it has been in news again. Law Commission, wherein it is trying to enforce any of the DPSPs. Anybody has heard of that? When we're talking about the directive principles of state policy, that the Law Commission has been in news in the past couple of days, wherein, they're talking about something which is mentioned in the DPSP about doing some research, giving some recommendations on something which has been a part of DPSP, has been in news a lot. Can you guess what it was? Anybody has the answer to that? What we are talking of? It relates to religion, has been in news. With respect to religion, something wherein the Law Commission is asking the various agencies to give them an idea, to give them recommendations, to get views of different actors. Yes? I'm sure the moment I write this, everybody's mind will go to what I'm saying. I'm talking about the UCC, the Uniform Civil Code. What is the Uniform Civil Code? Uniform Civil Code is another thing, something which is given under the directive principles of state policy, which tells us that, we should try, or India should strive to have a civil code or something, a uniform civil code, so far as the personal laws are civil law is concerned, because so far as criminal law is concerned, we do have a uniform criminal code. But if it comes down to civil law, when it comes down to personal laws, they're governed by various, your religion and things like that. So therefore, there is no uniformity in laws related to marriage and law related to succession, adoption, and things like that, right? So this is something which has been in news of late, because now the Law Commission is asking for recommendations from various people, from reviews as to what should be done, right? So different people have been asked this, right? So this is something which has been in news. Maybe we'll have another session on UCC and what Law Commission is talking about so far as UCC is concerned, right? But today's session is basically on sedition. So we'll move forward. This was basically a little bit of history of what Law Commission is. Becomes very relevant, since Law Commission's reports don't come every year, but they have been in news in this year, 2023. We've had a couple of recommendations, reports which have been made. So, something which becomes important both from your GK perspective for Clat as well as from your legal reasoning perspective, right? So from both your, both your sections of the Clat paper, this is something which has become very, very important, right? Okay, let's move forward. Now, let's understand who's who. As to when you look at the Law Commission, who are the members of the Law Commission. So when you look at the Law Commission, now this is something which we just did, 3 years, 31st August is what it has been given the extension for. Now, otherwise, when you look at the Law Commission, who's who, there has to be a chairperson. Present chairperson is Honorable Justice Ritu Raj Awasthi, who is the who was the Chief Justice of Karnataka High Court. Similarly, we have two full-time members, 3 of them. We have one Justice Sankaran, and then we have 2 professors. There is a member secretary, ex-officio members, part-time members. All these are your members who can together make the Law Commission, right? So when you look at the Law Commission, this is what the membership of the Law Commission looks like. Important from your GK perspective, not so much from your legal perspective, but yes, something which is current, something which is important for you to remember, right? So let's move forward. Now, next, let's come down to what we are here today for. Here we are today for what is it that the Law Commission has recommended so far as law of sedition is concerned. Now, when you look at that, this report, when was it given? This report was given on 24th of May, 2023. So this is the report. This is the report number 279. On 24th May, this was given on the usage of law of sedition, right? Who was it presented to? It was presented to Shri Arjun Ram Meghwal. He is the present Law and Justice Minister. Now, whenever such a recommendation is made, usually there is terms of reference which are given to the Law Commission that the government wants the opinion of the Law Commission on this particular aspect. So here it was in 2016 that the Department of Legal Affairs and Ministry of Law and Justice, they were the ones who had given a copy to the Law Commission of India that we need to study the usages of the provision of Section 124A. What is Section 124A? Section 124A is when you talk of sedition, right? So even in 2016, there was a need which was felt regarding that whether these the Section 124A, that is sedition law, whether there needs to be any kind of reform to this law, right? And thereafter, there's this judgment, which is this SG Wombedkar judgment versus Union of India 2022. Now, this is where the urgency came into being. That why is it that the Law Commission gave a report urgently? Now, this is the reason because under this judgment, the entire the matter went to the Supreme Court regarding the constitutional validity of Section 124A. Right? It was challenged that Section 124A is against fundamental rights. It's against the Constitution. It is something which should be scrapped. Right? Now, there were arguments which went on. So finally, what the Supreme Court said that the Supreme Court was assured by the Union of India that they would re-examine about Section 124A. So they said that let us investigate, so that the court should not be wasting time, but rather it should be given, the task should be given to the union government to check whether the law should be kept or it should be discarded. So that is when the role of the Election Law Commission came into existence, right? What was the most important thing about the judgment which was made on 11th May 2022? The most important thing in this was that while the union government was thinking or was giving recommendation or was analyzing whether 124A should be there, should not be there, what did they say? That the state government and central governments were to refrain from registering any FIR or taking coercive measures while suspending continuing investigations. Meaning thereby, what did they do? They put Section 124A, the law relating to sedition, in abeyance, right? What did they do? They put sort of a they put it in a position, they froze it in time. They said that night, from now on, you cannot have any kind of litigation or any kind of cases under 124A. So the law had been suspended for the time being, right? So this is something which is very, very important. And that is the main reason, because of the suspension, that the Law Commission has given its report urgently. It was given within a year of when this judgment came into being, right? So see, that is why 24th May is when the report came in, and 11th May was when the judgment was there, right? So this is the background why the report has come in now. Right. So let's move on further. So this is the reason why for you guys, especially, for Clat aspirants, sedition has been something which has been in news for the past couple of years. Very, very important to have a clear understanding of what the concept is. And right now we are looking at it from the aspect of the Law Commission, right? Okay, let's move forward. Now, when you look at the report which was given by the Law Commission, now the Law Commission has made certain recommendations so far as the sedition aspect is concerned, that okay, whether it should be there or not there. Now, obviously, whenever a recommendation is given, there is an entire process which goes on to ensure that they give the correct or the most deliberated recommendation to the government. So this was the entire process which was undertaken while they gave the report, right? So even the report contains, detailed analysis on all these issues. They took studied the genesis, development of the concept of sedition, how during the time of Britishers, the concept of sedition was introduced in India, and how at that time, the way it was used, right? So what was the concept that was there and how it has developed over a period of time, right? So it's not just the origin that they're talking about, but over a period of time, is it the same law which was there when 124A was introduced during the British era, or have changes been introduced, right? So all that was, that entire thing was done, that entire review was done, there was research done on that. Then it says reports of previous commissions, because understand that the present 22nd Law Commission is not the only commission which is talking about looking at reforming 124A. There have been previous attempts at reforming 124A also. So there have been recommendations made earlier also that how 124A should be changed, right? So they took all that also into consideration. They also took the consideration of the Constituent Assembly. So at the time when the Constitution was being made, should we have a provision of sedition? Should it not be there? So all those are also taken into consideration, right? Then judicial interpretation, the case laws, of course, I'm sure everybody knows the most famous case law here, the Kedarnath judgment. So they took reference to the Kedarnath judgment and other judgments on sedition law and how sedition law has been interpreted over a period of time. And this is something which is very important, the law of sedition versus your right to free speech, which is given under Article 19(1)(a), right? So your right of freedom of speech, of expression versus sedition. Is sedition something which you can put in the category of reasonable restriction, or you cannot put it in the category of reasonable restriction? This was something which was analyzed again in the report. Then they also analyzed it vis-a-vis threats to internal security. That when it came down to internal security, whether it's the Maoist activity or it's the militancy in the Northeast, JNK, and all other kind of secessionist activities which have taken place in India, how this law on sedition helps in curbing these activities. Does it have a role to play? It doesn't have a role to play? All that was also looked into. And of course, this is a very major thing, because this is the reason why the case ever went to the Supreme Court. The alleged misuse of Section 124A. Right, that how it has been misused, whether it has been misused or not. So that was something else which was discussed. And another very, very important thing, which was a part of the report, is when you look at sedition laws in other countries. This is something which lot of, if I'm sure all of you have read a lot on sedition law, so you would realize that a lot of these people who were against the concept of 124A being a part of IPC, they always write how in other countries it is not a part of their legal system anymore, whereas it is very much a part of our legal system. There have been claims made to the effect that UK, where the entire law of sedition began, it is not a part of their penal code anymore. But we in our country are still continuing it to be a part of our legal system, right? So all that was also looked into, all that was also dealt in depth by the commission when they gave their recommendation, right? So these were the basic things which they really looked into before giving their recommendation, right? So next, let's look at what were the grounds for their recommendation, right? They made certain recommendations, but after reviewing all this, there were certain grounds which they came up with on which your recommendations were based. Right. So next, the first thing that we look at here is this to safeguard the unity. And now, before I move on to the grounds, let's have a quick idea as to what the recommendation was. What was the recommendation? This is something which has made headlines, that the Law Commission said they were in favor of keeping the provisions of Section 124. They were not in favor of repealing, right? No repeal, rather they were in favor of keeping, right? Of course, they have recommended certain changes to be made to 124A. So certain amendments to 124A is what they have recommended, but they have specifically, categorically said that it should not be repealed, right? So repeal is something which they are against, but they are in favor of amendment of the provisions. Now, when you look at what were the reasons which they are giving, what are the grounds on the basis of which they made this particular recommendation, the first ground is they said to safeguard the unity and integrity of India. Now, when you look at this sedition, the concept of sedition, now they said that when you look at sedition as a law is something which is there in our penal, which is in the traditional penal law of the country. It's something which is a part of the IPC. Now, whenever we look at criminal law, the most comprehensive criminal law of the country or the major criminal law of the country is the IPC. So what the Law Commission said was that we might have certain other laws, specific laws in place, because people have said that if you feel that it is against the government, then we have laws like UAPA, laws which deal with terrorism, laws which deal with activities which are going to be taken against the government, secession or terrorist activities, all that are being taken care of under specific laws. Then why do we need, it to be under IPC? But Law Commission says that all these might be specific laws. These might be specific laws regarding terrorism, regarding other things. But when it comes down to, safeguarding the unity and the integrity of the country, the major criminal law of the country, the IPC, should also have a provision regarding that. Why? Because they said that when you look at the kind of, punishments which are given under UAPA and let's say the NSA is the National Security Act, which is regarding preventive detention. All these laws have very stringent kind of punishments, punishments which are very, very stringent, punishments which are very, very strict, and the kind of powers which the police has are very wide. So their recommendation was that every time, there is, a charge of sedition or something which is being spoken about the government, it should not be that you are going to these stringent laws, but rather your regular penal code should also have certain way in which you can handle a situation of sedition, right? So therefore, they said that in order to safeguard the security and integrity of country, it is, important that IPC should also be having some sort of a provision in that, especially considering, nowadays we have so much of social media which is there. The way social media is able to agitate people, the role social media plays in all these activities, it is important that we don't end up always going to a law which is very stringent, but something which is, your regular traditional penal mechanism, that is your IPC, that should also have certain provisions regarding that, right? That was their first ground for the recommendation which they made. The second ground which they had was, they said that sedition is a reasonable restriction under 19(1)(2). Now, as per 19(2), 19(2) gives you the restrictions which can be put on your 19(1)(a). Because I think everybody agrees that the freedoms given under Article 19 here are not absolute, right? We can also always have certain reasonable restrictions. And the reasonable restriction here, which comes into play, is something which relates to public order, right? Public order is something which is given under 19(2). Security of the country, that is something which is again given under Article 19(1)(2). So all these come into play, and they said that squarely when you look at sedition, and when you look at sedition from the way the Kedarnath judgment is talking about sedition, because very important here is that when you look at the recommendations and they're saying that 124A should be amended, what are they saying? They're saying that 124 has to be amended. How? This amendment has to be there vis-a-vis the way the Kedarnath judgment interpreted sedition. That means there should always be some kind of violence that is either happening or is being targeted, right? So whenever the case of sedition comes in, there has to be an element of violence involved, right? So therefore, the moment element of violence is involved, the question comes automatically under public order. So their idea was that since 19(2) already talks about public order, already talks about, the security, integrity of the country, so you're squarely covered under 19(2). Also, what did they say? They said that under the Kedarnath judgment, this issue has already been sorted by the Supreme Court. Supreme Court said that yes, whatever restriction sedition is putting on your right to freedom of speech and expression, it is something which is squarely covered under 19(2). Right? That is a reasonable restriction. So that was something which they said about the second point. Now, the third ground they said is existence of counter-terrorism legislation does not obviate the need for 124. Now, this is something which we just discussed when we were discussing point number 1 also. That just because you have laws like UAPA, you have laws like, what is UAPA? UAPA is your Unlawful Activities Prevention Act, right? So you have your UAPA in force. UAPA is for terrorism, right? In fact, this act was a 1967 legislation, and this law has also been in news because there have been various amendments which have been passed, whether it's the 2004 amendment, wherein the POTA, that is a Prevention of Terrorist Activities Act, which was, certain that was, done away with, and certain parts of that were added into the UAPA, making it sort of a very wholesome law so far as terrorism is concerned in our country, right? Again, in 2008, there were certain recommendations which were made. So there, time and again, there have been amendments which have made. But all in all, when you look at UAPA, this is a law which is regarding terrorism, right? You even have the NSA. NSA is a National Security Act, but then this deals with preventive detention, right? This does not deal specifically with, charges which are covered under sedition. And like I said, the Law Commission also feels that, when you have social media involved and you have other kind of charges involved, it should not be that, you have to go back to something which is so stringent, because when you look at terrorism laws, they are way more stringent than the regular laws, right? So 124A therefore should be there. It should not be done away with. That was the argument given. Now, next is when you're talking about sedition being a colonial legacy. Now, this is another ground. Now, a lot of people have been using this as a ground, saying that sedition should be scrapped off from the IPC. Why? They say that it's something which is a colonial legacy. So if it's a colonial legacy, what use does it serve? What purpose does it serve in the modern times? Now, Law Commission says that it's just because it is a colonial legacy does not mean it is not relevant anymore. Most of the legal framework which we follow till date, like we just, in fact, in the beginning of the session today, we were talking about how IPC is something which has been, the CPC, the Indian Penal Code, all these laws have been there in place since pre-independence era, right? So it is not as though after independence, we have changed our entire legal system. We did make changes which were needed, but the entire system was not scrapped. To scrap 124A just because it is a colonial legislation would not be a valid argument, right? So that is what they had said about the colonial legacy part. Then the last ground which they said is reality is different in every jurisdiction. Now this is what they are referring to when they say that the argument which was raised, that most of the developed nations, whether you talk about UK, you talk about US, talk about Australia, Canada, all these nations have done away with provision of sedition. Now, but Law Commission said that if you look at it deeply, if you actually study the provisions, then what you would realize that in these legal systems, it is not as though sedition does not exist anymore. Sedition does exist. It does not exist in their mainstream penal code. So it might not be a part of their, whatever equivalent to the IPC is there in their country, but it does exist. And how does it exist? It exists in the form of when it is being merged with other anti-terrorism acts, right? So here, like we are saying, people say that we do have UAPA. So instead of 124, you merge it with UAPA. So that is what has been done in these legislations or in these jurisdictions also. In these different countries, that is what has been done, right? So that's what the Law Commission said that. So, but for every country, the ground realities are very different. In our country, we do not want to club it only with the stringent anti-terrorism laws, but we want it to have a lighter punishment also. We want it to be more, something not very stringent. The people should not be going directly under UAP or NSA or any of these terrorism laws, but rather a law which is a little less stringent, right? So that is why to say that in different countries, law on sedition does not exist is incorrect, right? That is what the recommendation of the Law Commission is, right? Okay, chalo, those are the reasons given by Law Commission. Like I was saying, we are dealing with facts here today. We are not dealing with whether what Law Commission is, whatever your views on Law Commission are, but we are dealing with the hard facts, right? So these are the grounds given by the Law Commission, right? So let's move on forward. Now, we are going to the last bit of our session today. We are now going on to the recommendations, right? So what were the actual recommendations which were made, right? Now, this is something which is really, really important. Like that after on the entire process, the grounds and everything, let's now discuss what are the recommendations. Now, the first recommendation here, which was made by the Law Commission was, they said that whatever was the ratio of the Kedarnath judgment, that ratio of the Kedarnath judgment should be incorporated under 124A. That means, the Kedarnath judgment, what did it say? It says that unless the words used or actions in question do not tend to incite violence or cause public disorder or cause disturbance to public peace, the act will not fall within the ambit of section 124A. So basically, this is something which was recommended by the Kedarnath judgment. Now, there have been, this is something which is being followed. Why? Because it was a precedent set under the Kedarnath judgment. What the Law Commission is saying that, it is a precedent, but let's solidify it further. Let's bring in clarity wherein what we do is we make it a part of 124A, right? Let it not just be a, something which stand as a precedent given by the Supreme Court. Rather, let's make it a part of 124A. That's the first recommendation which is made by the Law Commission. Now, the second recommendation says procedural guidelines for preventing any alleged misuse. Now, this is something which has been in news a lot, that there has been a lot of misuse of 124A. So let's understand how the Law Commission wants to tackle it. Now, what they are saying that even though, you might have this entire provision under 124A, you change it to say that you should not incite violence and everything, but still, sometimes in ground reality, there can be a misuse of 124A. So what they are suggesting is that there should be some procedural safeguard. Procedural safeguard is that, it cannot be that the moment you feel that there is sedition happening, you file an FIR and the person gets arrested. Rather, before you file an FIR, they are saying that there should be some safeguard. Now, what is it? What is the safeguard that they have kind of recommended? Now, first they said that there should be some guidelines which are issued by the central government. That is one thing they can do, that they issue some guidelines. Alternatively, there's an alternate also which they have provided. Alternate says that there should be a section 154 of CRPC, which basically talks about FIR and just registration of FIR and all. So they're saying that there should be an amendment which should be there, under which that no first information report under 124 can be registered unless a police officer not below the rank of inspector conducts a preliminary inquiry. Which means that just because a person feels that there is sedition happening, you go ahead and file a case of sedition, FIR would not be lodged directly. First, there would be a preliminary inquiry by an inspector, and only thereafter would the FIR be filed. So this is basically sort of a deterrent. It is a deterrent that the section should not be misused. Before 124A, instead of it directly, anybody having a right and anybody being arrested, this is going to act as a deterrent, right? So anybody, when they're filing a case under 124A, there would think twice that, okay, first there is going to be an inquiry, only then the arrest is going to happen, or only then the FIR would be registered, right? So that is another alternative which has been given by the Law Commission, right? So these two are there. Then let's move on. What is the next recommendation? Now, the next recommendation is regarding the punishment. Now, when you look at section 124, the punishment for 124 is very odd. Now, there are 2-3 different types of punishment, it says, could be given under 124. It says it could be either an imprisonment for life. So there's life imprisonment. Then it says, or imprisonment up to 3 years only, right? So either you are put in for life or up to 3 years, and there is only fine, right? So therefore, it's a very, odd sort of a punishment that is given. So it's either life imprisonment, and there is nothing in between life and 3, right? So under 3, life or fine. So this is kind of odd. So what they have recommended is that chapter 4 of the IPC. Now, what does chapter 4 of the IPC talk about? Now, when you look at chapter 4 of the IPC, chapter 4 of the IPC, chapter 6 of the IPC talks about offenses against the state. Right? So any kind of offense which is against the state, what kind of punishment is given? Like, so, when you talk about chapter 6, it talks about things like waging war against the government of India, or, an intention to wage war against the government of India. So all those kind of offenses are in chapter 4. So what are the kind of punishment which is given under chapter 4? That is the kind of punishment should be given, right? Not such odd punishment. So like, in chapter 4, there's sometimes the punishments given that, okay, up to 7 years of imprisonment can be given with or without fine, things like that, or only fine. So there should be some sort of a parity in the way punishment has been described for other offenses under part chapter 4, right? So that is something which they have recommended, right? So they suggested that the provision be revised to bring in consonance, right? So that is something which is important. And how is it going to help? It is going to help because this would allow courts with greater room to award punishment in accordance with the scale and gravity, right? So it should not be that for every kind of when it comes down to, let's say, court is hearing a case on sedition, the court's hands are tied. Either they give punishment for life or it's only 3 years, right? So that is something which is very, very wide. The punishment is the power of the court is is being provided in not a very clear or a very just manner, right? So that is something which the Law Commission has recommended. Now let's move on to the last recommendation. Now, the last recommendation which has been given is the proposal for amendment. Now, 124, like I said, to begin with, what have they said? That 124 should not be repeated. Right? They have said that it should be there, it should not be repeated. Now, how do they want it 124A to look like is what they have said. Now, the parts which are in bold, this is something which they have asked for changing. So when you look at the first part, which is in bold, this here is regarding the punishment. So the punishment, change in punishment, and they've also added, with the tendency to incite violence or cause public disorder. So these words have been added as per the Kedarnath judgment. And also they have talked about the punishment with life, to which fine may be added, or imprisonment of either description, which may extend to term of 7 years. Now, like I was saying, the other provisions under Chapter 6 of the IPC, which is talking about offenses against the state, there generally the punishment is up to 7 years, right? So there is a parity which is being made so far as punishment is concerned. Okay, so this is one. And of course, the last explanation for, this is again in view of the Kedarnath judgment, which they have said. They said the expression tendency means mere inclination to violence, incite violence, or cause public disorder, rather than proof of actual violence or imminent threat to violence, right? So this is something just to add more clarity to the section. So that, because end of the day, what is the main reason why this has been challenged? That 124, the way it is worded right now, it is not clear. It is very vague, right? So that is how it is being misused. So this is what the recommendation of the Law Commission is. Okay, so so this is where we come to an end to today's session. I hope this session was helpful. I'm again repeating, this was a very specific session on sedition, very specific sedition on what Law Commission has recommended, what are the grounds, and how it has made the recommendations, right? I would recommend, this is my recommendation now, that you guys go through this video clearly and make your notes on sedition per se, the concept of sedition, the Supreme Court judgment which has come on sedition, how it is pending, and also now to those notes, which I'm sure those of you who've been preparing for Clat have been kind of familiar with the concept of sedition. This Law Commission's recommendation should be in addition to your notes, which are already there. That is why you must have realized in this entire session I did not really go on to discuss 124A. Because here I'm presuming that 124A is something you are familiar with, right? So we've gone on to only discuss what are the recommendations of the Law Commission. Okay. Chalo guys, then take care everybody, study hard, and do read about this at your own leisure also. Okay, chalo then, take care everybody. And okay, little bit. Oh, I just realized, did I introduce myself? No, I did not, right? So I am Neha, and who was taking your entire session on the 22nd Law Commission's recommendation on sedition. And, to end on a note, we are Clat Possible. And if anybody needs any kind of help so far as preparation for your Clat exam is concerned, I would recommend that, you can get in touch with us through our YouTube channel, on which we are available right now also, and otherwise also, these are our social media platform, our handles through which you can get in touch with us. So anybody who is thinking that you want to prepare for Clat, or you're already in the process of preparing for Clat, but need that extra edge, need that extra nudge, which would help in your preparation, then do get in touch with us. Okay, thank you so much, and keep up with your preparation. Do read about what we just discussed on your own also. Okay, take care everybody. Bye-bye. Thank you so much.